A new president was elected in Sri Lanka on the 9th of January 2015. He promised change and reform. The abolishing of the executive presidency was one of the topics extensively discussed at the political stage. 100 days after, where does the country stand today? Has the government been able to fulfill its promises to the public? A very good evening and welcome to Face the Nation right here at Stein Studios in Ratmalana, where we will be discussing the problems and the concerns of the general public. The topic of discussion today is the 19th Amendment to the Constitution and the 100-day program. This is incidentally the first English language political debate program in Sri Lanka. We intend to feature 3 guests who would be drilled by our journalists. Without further ado, let's meet our guest this evening. Deputy Minister of Investment Promotion and Highways, Eran Wickramaratne. Attorney at Law, Srilal Laktilaka, who is also the Presidential Coordinating Secretary. Dr. Dayan Jayatilaka, a celebrated diplomat of the previous regime and also a political analyst. Let me also briefly introduce you our panelists, our journalists this evening as well. On to my right is Nadim Majid, senior producer attached to News First. On to my immediate left is Sonali Wanike-Baduge, who is a journalist who has been awarded the State Television Awards as well. And also on to my far left is Faraz Shaukat Ali, who is an independent business journalist. Now, every speaker will get 3 minutes for their opening remarks, and followed with a 15-minute questioning period by our journalist. And then each speaker will get 3 minutes to bring in new arguments and rebut the points brought forward before. And then followed with a 20-minute Q&A with our journalists. And then for the closing remarks, each speaker will get 3 minutes each. Please note that no new arguments can be brought forward. Let's get the ball rolling. Mr. Eran Wickramaratne, the ball is in your court.
Thank you. Pleased to be here at your inaugural launch of this program. I think on January 8th, there was a big change in this country. We got a new president, President Maithripala Sirisena. It was also the beginning of a new political culture in this country. I remember the period just prior to the presidential election when people were filled with fear. We didn't have the freedom to actually exercise our political rights. I know this personally myself, working very closely on the presidential campaign, how we were being watched very closely by intelligence services and so forth. I arrived at my home one day and actually found vehicles parked there, actually marking every vehicle that was actually coming and going outside my home. Many people used to talk to us on the telephone, and after a while they would say, we can't tell you all the details, we need to meet you privately to actually have a conversation. This is the political culture that actually prevailed. The president himself has said that if I had not won this election, that my life would have been in danger. We could truly say that there has been a change in the political culture. With President Maithripala Sirisena coming in, and also the example President Sirisena has set, I think he has set a very high standard for public life in this country. Yesterday was the first occasion after the presidential election that he addressed the nation, and while he was addressing the nation, he said, I have made no phone call to any member of the judiciary. I have not met any member of the judiciary. I have not made any phone call to any commissioner of any independent commission. And I think these are very, very high standards in public life that have now been set after the new culture that was ushered in on the 8th of January. That's not to say that we are having a smooth ride. That's not to say that this government is a perfect government. I think this government is having issues. It's a bumpy road. It's a culture. A culture takes quite some time to change. We could change the rules, we could change the laws in a short period, in 100 days. But for a culture to change, it takes much longer. Apart from the change in culture, the new government has set about actually bringing new laws into Parliament. The one that we are presently going to be debating in a few days' time is the 19th Amendment to the Constitution, which I will deal with in a few minutes or maybe in my next round. Also, we promised certain relief measures, economic relief measures to the public. We brought the prices of essential foods down. We brought the prices of energy down, petrol, diesel, kerosene. We brought the prices of gas down. March was the month in the last decade which had the lowest inflation in any given month. It was 0.11%. And I think everybody had a very, very happy New Year because there was such a big drop in the cost of living and also an increase in incomes, particularly for public servants.
Thank you very much. That, of course, was Deputy Minister of Investment Promotion and Highways, Mr. Ran Wickramaratne. Attorney at Law, Srilal Laktilaka. You are now the Coordinating Secretary of the President. 19th Amendment and 100 days. Where does the country stand today?
Now, first of all, I have to mention I am participating in this debate on my personal capacity, not as the Coordinating Secretary of the President, and my views are given here, stated here, are entirely personal views.
We do respect that.
Thank you very much for inviting the inaugural session for debate, and I feel privileged and honored. When you start talking about 19th Amendment as well as the stated 100-day program, I need not to elaborate. Everybody knows what is happening and what has not happened. But the most important thing here is to understand the context where we are now going through. 3 months back, 6.2 million citizens, I am emphasizing the word citizens, of this country has given their mandate to change the constitutional monarchy existed at that time. This constitutional monarchy is need not to elaborate, but we all know the lawlessness, the corruption and other illegal practices happened at that era. People wanted to change. The people wanted to change, and the common candidate, then Mr. Maithripala Sirisena put forward the political platform on three slogans mainly. That is to change the executive system or executive presidency, change the 18th Amendment and the draconian governance pattern of that time prevail, and also to introduce new electoral system. These three were the main among the several policy platforms put forward by the 100-day program. These three policies were introduced or proposed to the people to establish a humane, democratic and civilized society. So whatever the lapses of the 100-day, as yesterday Mr. President has stated, we have achieved. Now we have good governance, we have law-abiding society, rule of law, etc., etc., everything which we are talking under the heading of good governance. So this is the start.
Thank you very much, Attorney at Law Srilal Laktilaka. Dr. Dayan Jayatilaka, a senior political activist, he has been very vocal on the present situation in the country. 19th Amendment to the Constitution and the 100-day program.
Well, I agree with the London Economist, which wrote a piece about the 100 days yesterday. And the title of that was Frittered and Frazzled. And the Economist, which is no fan of the former President Mahinda Rajapaksa, concludes by saying that the best thing the new government can do is to fulfill at least one of its pledges and go for a quick election. So I think that's right. It's not that there aren't good things that happen in the 100 days, but that happens whenever there's a new administration elected. In my lifetime, I've been through, 6, 7 changes of government. The new brooms always sweep well. There's always a period of relaxation. There's always a decompression, and we've experienced it this time. I read the daily news now. I didn't read it when President Rajapaksa was president, because it was a horrible newspaper. Now it's a decent newspaper. So there are good things. The 19th Amendment has some good things, but it's far more dangerous than positive. I would have much preferred had the 19th Amendment stuck to restoring the independent commissions, albeit strengthened, and reimposing the term limits on the presidency. Now that would have meant that the authoritarian aspects of an essentially good system, the executive presidency, which we have in most of the progressive liberal countries in the world, would have been retained. But what we have is a dangerous situation, and I'd like to spend this time quoting from somebody who's quite on the opposite side of the spectrum from myself, and that's Professor Kumar David, who, writing last weekend, said, and I quote, 19A, today's flop, tomorrow's hazard. I am puzzled that no other commentator in the print or electronic media, as far as I know, has picked up on the terrible Achilles heel of the 19th Amendment. It's designed for the coexistence of two equally strong centers of state governmental power. I am puzzled that no one else perceives that future constitutional deadlock is staring Sri Lanka in the face. When crisis arrives in Lanka, it will be destructive partisan attrition. And he goes on to say, it is a pity that there has been no discussion of what will be major impediments to the stability of the state in time to come, the creation of two equipotential power centers in President and Parliament. Now that is Professor Kumar David, who actually argues for the abolition of the executive presidency. But my point is, you could have had a much better deal. You could have had the trimming of the excess. The presidency was a good idea, President Jayawardena's idea, but it was top heavy. And if the 19th Amendment had been limited to the restoration of the independent commissions and the restoration of term limits, we would have had the best of all possible worlds. Instead, we have this dangerous situation that Professor Kumar David has pointed out.
Thank you very much, Dr. Dayan Jayatillaka. I open the floor for questions from the journalists. Now start off with Naveen Majid.
Thanks, Amir. I'll start off with an open question, actually a question directed at Deputy Minister Elan Wickramaratne. The whole purpose of the 19th Amendment, when it was brought in, when it was being talked about even before the election, was that it would abolish the executive presidency and restore democracy and freedom to the country, and bring sovereignty back to the people. Those were the stated aims. Does it do that, and how?
The United National Party's view was that the executive presidency should be abolished, and that decision had been taken by the United National Party several years ago. However, and we campaigned ourselves on that when we went door to door, saying that we will abolish the executive presidency. As you recognize, we don't have a United National Party government. We have a government that consists of many parties and many people from many different parties represented in the cabinet. We also need to realize that any constitutional amendment, it will either need a referendum, or if it does not need a referendum, at a minimum it needs a 2/3 majority in Parliament. And therefore you have to build a consensus to get any constitutional amendment through Parliament. So the 19th Amendment, if you want, is a consensus building effort to get people to agree to reducing the powers of the executive presidency. So in that sense, it doesn't go as far as contemplated earlier, but it certainly strengthens the sovereignty of the people. In Article 3 in the Constitution, it very clearly says that people are sovereign. It's people who are sovereign. It's not the executive. It's not the president who is sovereign. The president is there to carry out the will of the people. Now the debate hinges around, what are what executive powers, and can these executive powers be shared? I think the court has very clearly stated that these executive powers can be shared. But at the same time, the court made a determination that there are certain limits to it, right? And if it, in their view, violated some entrenched clauses in the constitution, then that was not possible. And therefore it struck down certain proposals that were put forward, saying that it needs to go for a referendum.
The accusation now is that these clauses, some of these clauses that have been taken out, we've seen this accusation being leveled by the Jatika Helurume specifically as well, that the UNP is surreptitiously trying to bring these clauses back. For example, I'll draw your attention to page 38, clause 28, which states that which deals with the Commissioner of Elections, which inserts Article 104 GG. The initial draft that was gazetted said a public officer. That has since been amended, as you're aware, on the draft that was presented the 22nd night, I believe, at 8 p.m. It has since been amended to a public officer, employee of a public authority, companies in which 50% or more is owned by the government, private and state broadcasters and telecasters, and news media print. A. Refuses or fails without a reasonable cause to cooperate with the Commission, referring to the Elections Commission, to secure the enforcement of any law relating to the holding of an election or the conduct of a referendum. Or B. Fails without a reasonable clause to comply with any directions or guidelines issued by the Commission under subparagraph B of paragraph 4 of subparagraph A of paragraph 5 respectively of Article 104A, shall be guilty of an offence and shall on conviction be liable to a fine not exceeding 100,000 rupees or to imprisonment for a term not exceeding 3 years or both. How does this guarantee freedom of expression?
Yeah, the first thing I would like to completely disagree with you is that the UNP tried to surreptitiously introduce anything. I think that would be very, very misleading. There was a constitutional amendment, the 19th Amendment, which was gazetted, which was agreed by Cabinet, which was put forward. And as you know, coming through the normal process, it was challenged in the Supreme Court. At the point it was challenged in the Supreme Court, some amendments were put forward by the Attorney General at that time. And those amendments were also considered, I guess, in the Supreme Court making its determination on what it really needs to, what could be retained in terms of Parliament approving and what would need a referendum and so forth. So I would completely dismiss that idea. Now, the other thing is, this is the constitutional amendment that is now tabled in Parliament. This is the one that we will be debating, and we will be debating and proposing only a constitutional amendment which is in line with the determination of the Supreme Court. That's as far as we will go in actually proposing this constitutional amendment. If there are amendments brought up at the stage, right, at committee stage, then Parliament is there. They could debate the amendment. In any law that is brought at committee stage, things are brought, and that could be debated. But I certainly don't think that anything that would be basically not consistent with the view of the court will be entertained.
Minister, do you think that this amendment is that specific clause that I was referring to? Do you think that it is in line with the principles of freedom of expression?
No, I think on the principles of freedom of expression, we believe in a free media. We believe in a free media. We believe in a media which also needs to be self-regulated. But I think, as you know, even when a code of conduct was brought for the media in this Parliament about a year or a year and a half ago, we opposed it, the code of conduct. Even though we were often victims sometimes, we opposed it because we believed in the freedom of the media. And I would still say that it is up to the media to regulate itself. That is a principle that we will hold to.
Dr. Jayatilaka, I think we should ask the same question from Dr. Jayatilaka. Dr. Jayatilaka, do you believe the 19th Amendment of the Constitution in any way tarnishes or suppresses the media freedom?
No, I must say that I'm familiar with the discussion and the apprehensions, but I must also confess that that has not been my main focus. So I do not get that vibe of the 19th Amendment, or maybe that's not my main concern. My concern is the distribution of power and the decision-making process, and I find this 19th Amendment very fraught for the same reasons that Professor Kumar David is critical or apprehensive about it. Those are my apprehensions.
Sonali?
Yes, my first question is to Mr. Laktilaka. Now, anti-corruption was a massive slogan of the incumbent administration to crack down on money laundering, massive scale fraud. Article 12(1) of the 1978 Constitution says, and I quote, "All persons are equal before the law and are entitled to the equal protection of the law." In your opinion, is this being done?
Yes, I'm very quite sure that rule of law is applicable for every alleged crime. So, and not only that, not only Article 12, Article 13, 6 is also applicable, that is a presumption of the innocence. So, what we have done through the campaign which we have started to bring forward necessary information for legal authorities, and what the government or bribery commission as well as the police department has done, they have gone through this information, and once they found there is a prima facie evidence against any person, they have asked to come and give a statement. Giving a statement is not a violation of any of those rights. So that is the first thing. Second thing is, depending on the crime, under the Criminal Procedure Code, there are provisions to remand them. So this is perfectly all right, and I mean we are very much comfortable with the way things are happening. So anybody can criticize what is happening. Now, yesterday also I have seen that somebody was saying that even commission is politicized, the agenda is the selection process of cases are politicized. That is not the case. I mean, now there are, on the movement which I belong, the anti-corruption movement, we received more than 1,600 complaints. Out of that, so far, we have gone through this information and we have filed or lodged complaints only for 100, because most of the cases, when from our level, this is entirely voluntary exercise, when we see that there is no fit case to be reported, we have rejected most of the information. Likewise, the CID or the special units which were set up under the IGP are going through those procedures. So therefore I am very much comfortable with the way things are happening. Now there are political noises. Political noises are different thing. Now I heard that the previous president has said Mr. Basil Rajapaksa is innocent when media has asked this question. Yes, we are saying presumption of innocence is applicable to Mr. Basil Rajapaksa also. Until he is proven guilty, he is innocent.
So you said, Mr. Sriraj Laktilaka, you said that 100 cases were filed by you all with the bribery commission.
Not filed, we have lodged
complaints. Yes. How many have been investigated so far?
I don't know. Both sides, CID as well as for the Bribery and Corruption Commission, we have lodged or forwarded on behalf of the citizens. We have tendered this information.
Dr. Jayatilaka, satisfied with the 100-day program?
Well, no, I have a problem with what Eran was saying. Now, he says that the UNP was completely transparent and above board and so on. Then I fail to understand why all of us saw on national television one of his cabinet colleagues, Mr. Champika Ranaweka, repeatedly accusing the United National Party of an attempt at a constitutional coup or constitutional conspiracy. Now, he may have been overdrawing it, but I think there was definitely something wrong in the process. Now, in the first place, it's a minority government. And I know of no example of a minority government, unelected, it hasn't won an election, attempting something quite as radical or drastic as a large-scale constitutional reform in 1972 and 78. both administrations have brought in new constitutions, had a two-thirds majority. The 13th and 18th amendments, contentious as they were also by administrations which had two-thirds majority. So the UNP probably pushed too hard because it was not an elected administration. Now, I think the problem is when you bear in mind what the UNP really tried to do and failed. If you take the what I call the Kottu Roti version of the 19th Amendment, which I was given day before yesterday, with all these things crossed out and so on, you can see what the Supreme Court ruled out of court, as it were. When you read those, you understand that what the UNP submitted, what it tried to do, was a huge transfer of power to the post of the Prime Minister. And the Supreme Court said no, that needs a referendum. So it's only when you check out what they tried to do that you can understand why there would have been apprehensions. And certainly when your Gazette is dated March 13th, but the Cabinet meets on the 15th of March, and then there's a debate in Cabinet, and then there are 12 pages of amendments which your own Cabinet colleagues say should have been part of the Gazette and could not be adjudicated upon because they were referred to the Supreme Court, but the Supreme Court can only adjudicate if there are petitions, and there couldn't be petitions because these were not part of the Gazette. Then you have a problem of transparency. That is why there are these lingering apprehensions and the lack of a consensus, the lack of an atmosphere of confidence building necessary for the smooth passage of a constitutional reform. If it gets through, it will get through only because President Sirisena, as the leader of the SLFP, has made a pitch for its passage. That's all.
Right. Thank you, Dr. Jayathilaka. Deputy Minister, I'd like to ask you now, the Elections Commissioner said that in the event there is electoral reform, or if the electoral system is changed, then it will take some time for parliamentary elections to be held. Will Parliament be dissolved on the 29th?
I think the dissolution of Parliament is in the sole discretion of the Executive President. And I think anybody who tries to speculate or say something on that is only speculating. And I think we will respect that. If you were to ask me a slightly different question, what would I really like to see? I would certainly like to see the 19th Amendment passed, and then Parliament dissolved, and a new Parliament be elected, a Parliament which then has a mandate to take President Maithripala Sirisena's program forward. That's what it would be desirable. We are hoping that will happen, but we can't prejudge that. I think it's in the hands of the President.
Faraz, quickly, a question.
To Mr. Wickramaratne. The 100-day program promises action against corruption. Can you explain as simply as possible why is that there's no action against the governor of the central bank?
We certainly promise to work at unearthing corruption, bringing to justice those who are corrupt. And in that process, the government has followed the traditional way of doing it. You have the Anti-Bribery Commission, you have the CID. In addition to that, the government also created a new institution called FCID. And also yesterday the President announced that there is going to be a task force called the State's Assets Recovery Task Force. And all this is done basically to eliminate or to minimize corruption. The case of the governor of the central bank has been under investigation of a committee. That committee's report was to be presented to Parliament last week on Tuesday. Because of the disruption of Parliament, that was not produced in Parliament. I think that committee report will be in Parliament this coming Monday or Tuesday, because there are 2 sitting days in which this report will be presented. Depending on the findings of that report, right, action will be taken where necessary, either by state institutions, or it will be referred to the judiciary, or if it needs further investigation, it will go for further investigation.
But in the meantime, we're told that the governor of the central bank is actually back at work.
I frankly I don't know that, but what I know is while the investigation was going on, that he was on leave.
There's another point too. With all these delays, this committee has no legal standing. It's a collection of 3 lawyers of the UNP who the Prime Minister's put together. He could have put together any 3 people. But these 3 people have no legal standing. And so it appears that there's like a whitewash going on.
Yeah, I agree that this is an investigative, a preliminary investigative committee with a very limited terms of reference. I agree with that. The fact that they are lawyers does not necessarily make them disqualified for making the inquiry. But I think the point is taken that if the report is not seen as credible, then clearly in the eyes of the public there is an issue, and I can see if there is an issue. But when this issue first turned up in Parliament and the Prime Minister made a statement in Parliament, the Prime Minister said this, and I reinforced it when I contributed in that debate, saying that beyond the committee that has been set, that we invite the opposition in Parliament to set up, right, a parliamentary select committee to go into this matter, so that Parliament will be fully satisfied with what happened and what did not happen. And the Parliamentary Select Committee could still be set up even after this report is tabled, because we all want to satisfy ourselves that what happened has actually is above board, is within the law. Those who are guilty must be punished. But if somebody is not guilty, then these committees must ensure that justice is also done by those persons.
Before we go for a break, Attorney at Law Shreya Laktilaka, you are a lawyer by profession. Pending a report to Parliament, can a public official resume duties again?
First of all, I must say that for expressing my opinion as an independent person, I was severely criticized within the Parliament under the privileges existed for the politicians on this particular issue. So therefore I am a bit reluctant to express my view on this matter, but you are correct. As Deputy Minister has stated, there is a preliminary, if there is a preliminary inquiry according to the Establishment Code, the most appropriate action is whatever the competent relevant authority has to take a decision to suspend his, if there is a prima facie offence he has committed, then he has to suspend and issue charge sheet. It's applicable for governor also. And also in such a situation, such a public official cannot take over that duty. So that's the first thing. Second thing is, that's why at the beginning we have stated this particular offence, or whatever the alleged offence, is very complex. It has its own complex nature. In contract of law, we are saying this was our stand. There was a fiduciary relationship between the primary dealer and the official. So for that you need to understand certain circumstantial evidence.
Dr. Jayatilaka, your thoughts on this?
Yes, I think that is the question. How on earth is it possible for the commanding heights of the economy, the central bank, to be governed by a non-national of Sri Lanka? I don't mean a dual citizen. I mean somebody who has relinquished his Sri Lankan citizenship. That means he has no stake in this country. And this is the top post in terms of economic or macroeconomic policy, financial policy. And it's not the only thing that has happened. I gather that the Institute of Policy Studies is also getting a head who's no longer a Sri Lankan citizen, not a dual citizen. So, since Mr. Bandanayake terminated the contract of John Exter and made Enu Jawar the governor of the central bank, we've never had non-nationals as governors of the central bank. And I think the problem starts from there. And Shiral can correct me if I'm wrong. I think President Sirisena took some days, this was going back and forth, before he allowed the appointment to be made. This was controversial from the get-go.
The 19th Amendment to the Constitution and the 100-day program. We will be right back on Face the Nation after this short commercial break. Stay connected. Stay with us.